I'm Nicole Ganara, Principal Immigration Attorney here at Manifest Law, going to answer some of your common concerns and questions when it comes to filing petitions. You have to think about immigration as if you are getting your place in line. Whenever you go to the DMV, you usually get a ticket. The earlier that you get your ticket, the earlier in line that you are going to be. Even if things retrogress, even if things can pause, the reality is, when did you get your ticket? The earlier your ticket number is, always the better. Another thing to consider is that the sooner you file, the more certainty you have locked in. When you file a case, USCIS has to apply the laws of the time that you filed that case. That means new changes generally cannot be applied retroactively. The last point I'll make here is priority dates are informed by law, but presidents can still affect how fast the line moves. By deciding which cases to process first, tightening or loosening standards, speeding up or slowing visa interviews, or even changing policy guidance, an administration can make the wait feel longer or shorter. Even if your place in line stays the same, that's why filing early matters. Remember, there are many steps towards deportation. It's not that you're immediately picked up and sent out of the country despite what a lot of news reports have said. If you're filing for an EB-1A, an EB-2NIW, or an O-1, so long as you have filed a truthful petition and you have been maintaining your underlying status, there really shouldn't be a strong consideration when it comes to deportation risk. Additionally, the Trump administration recently announced it is reviewing more than 55 million already valid visas for any signs of violations. Under this continuous vetting process, a visa can be revoked quickly. At this point, there could be a benefit to moving forward with a green card that can protect you better than a temporary visa. The longer you wait, the more exposed you are to sudden changes that could close doors instead of opening them. A USCIS denial for your EB-1A, EB-2NIW, or O-1 application does not impact your ability to file a brand new one, along with other applications for different visa statuses when USCIS receives that new application. Let's say you refiled an EB-1 after getting a denial. USCIS has to adjudicate that application on its own merits without considering the previous denial, unless that previous denial is on specific grounds like fraud, criminality, misrepresentation, inconsistencies between applications, or anything that could be considered a strong violation of status. Your visa and your work status will not be impacted by a self-petitioned application because USCIS will not inform your employer that you've filed such an application. So long as you maintain your underlying status when you file an EB-1A or an EB-2NIW, it should have no impact with your ability to continue working with your current employer.